So we move to the technical session 16, brand protection and anti-counterfeiting strategies. Can I have the panel here? Moderator Nihit Nagpal, Associate Partner SS Rana and Company. Advocate Shhaurya, Managing Associate Stratjuris Law Partners. Sameet Gambhir, VP Corporate Law, Company Secretary, DCM Shriram. And Harsh Aggarwal, Joint GM Legal, Havells India Limited. So safeguard your brand legacy. Explore cutting-edge strategies for brand protection and counterfeit threats. Allow me to introduce the moderator Nihit Nagpal, who is an associate partner of SS Rana and Company. Is a master's in business law, leads the dispute resolution team with over 11 years of experience. He advises globally on IP, corporate and consumer matters. Nihit appears in the top Indian courts, handles alternate dispute resolutions and contributes to leading books on Indian commercial litigation. He is a committee member for ADR in India, for IBA and INTA. He actively engages in international associations. Thank you.
Good morning, everyone. With me, I have a panel which needs no introduction. Mr. Sameet Gambhir, Vice President and Company Secretary, DCM Shriram. Sameet Gambhir, FCS LLB Vice President and Company Secretary of DCM Shriram Limited, brings nearly 30 years of expertise in corporate legal, risk management and company secretarial matters. Recognized as a top in-house counsel by Forbes India and the Legal 500. Sameet excels in corporate governance, M&A, regulatory affairs and compliances. Awarded for his legal acumen, he leads award-winning compliance team and is actively contributing to industry committees, demonstrating his influential role in the legal fraternity. And I also have with me Mr. Harsh Aggarwal, Senior General Manager, Legal, Havells India Limited. Harsh, with 20 years of expertise, serves as Senior Legal General Manager at Havells Group, specializing in corporate advisory, litigation and brand protection. He navigates diverse legal issues globally. Harsh excels in IP and non-IP domains, handling matters from trademarks to environment protection, recognized with Legal Era Under 40 Rising Star Award 2018. He pioneers automation tools for effective legal management. And with me, there is also Mr. Shhaurya, who is Managing Associate with Stratjuris Law Partners. He has been handling a lot of brand protection and anti-counterfeiting techniques at his law firm, and especially covering SAARC region such as China. So we have tried to divide this session in 3 parts. First, we'll talk about the prevention. Then we talk about the diagnosis, and we talk about the cure. So first, how we prevent a brand as a whole. What are the best practices? What are the challenges in protecting a brand? So if I may start with Mr. Aggarwal, that what are the best practices at your organization, that how you engage in protecting a brand, like basically how you make your house strong so that there is less attack.
Good morning, friends. So as you know, Havells, it is a primarily Indian company having more than 90% of its entire product range being manufactured in India, and strong footprints for its products in Africa. And 5 to 10% of our products are manufactured in China. So as it would be, so the difficulty other than the products which we have for in the Indian subcontinent, the main problem area which we face for piracy of our brand is primarily in Africa. So the source market for our products which we face in Africa, it is primarily originating in China. So there are 2 kinds of difficulties which we face for the products which are originating in India, and the final market itself is India. And the other, I said, ones originating from China, having no connection with India and ultimately landing in African markets, both east, west, and a little towards the northern side of Africa as well. So, being a brand of global presence, what is most important is to identify the places where your business intends to expand and where it intends to create potential markets. The first and the foremost thing is to have your brand registrations in place for all the appropriate classes for the products in which you are presently in and in which there is a prospect for the business to expand, for the cognate goods, for the allied goods. Like initially, Havells was primarily an electrical company, but with the acquisition of the Lloyd brand, we have diversified from electrical to electronics. So even in electronics, the initial products were only air conditioners and electricals and the televisions. But progressively, even for the Lloyd brand, we are expanding the range of the goods beyond televisions and air conditioners to refrigerators and washing machines. So that is the kind of the vision which you need to have, that presently I have two categories of goods, which are my basic bread and butter for the business. But progressively, as the business grows, we have to expand the product range. So you have to anticipate and be in regular touch with the business as well as the management to understand what is their vision regarding the future territories in which they want to expand the business and the product lines. So having registrations not only in the present classes of products in which you are dealing, but also actively anticipating the way the business is going to take its shape in the next 4 or 5 years and securing your rights in the brand for the relevant classes in the relevant territories. So that is the first and the foremost thing which we have as a matter of practice. So there are countries in which we had registrations for almost 3 or 4 years, but there was no business. But in fact, we had to make some nominal sales to keep our registrations alive and not to face actions for non-use, because the business was still yet not mature enough to have a commercial presence. But because we had the brand registrations in place, so we had to protect them for any actions against the non-use cancellation. So that is the kind of horizon which we take, that 4 years, 5 years, even 7 years are there. There are some instances in some countries where we started business as late as 7 or 8 years, but we had registrations which had in fact had 1 or 2 renewals as well.
So taking from there, so it's quite important to foresee it is very important for a in-house legal counsel to understand that in what business they actually are, and in future how they are going to diversify their business. So that's very important when you are protecting a brand. So I would like to have insight of Mr. Gambhir on this, that is there any diversification which you have faced in your organization, that you started with a line of products and then you have further diversified, and how you attempt to make your house strong from the attacks?
Yeah, sorry. Thanks, Nihit. I think, he has actually covered everything what an in-house counsel need to understand. Sorry, I have a bad throat. And, the kind of preventions, kind of registration, kind of policies we have to make. So I think what I understand is that it's very important that you need to have, as an in-house counsel, you need to have, if required, a separate IP division or a separate, brand protection division. It's very, very important nowadays, because it is actually a lot of value in it. And, we didn't do any diversification, but yes, when we were expanding a lot, we really faced these kind of issues that, when we were expanding in other 1 or 2 more products and all, and then we realized that, getting the brand registered, getting the name registered, and getting all the things registered in different categories is very, very important. Because the moment you even think or anticipate of doing something, before that, there are people in the market, there are bad actors in the market who want to take advantage of that. So I think it's very important that you take a very, very proactive action on those whenever you are diversifying or, expanding or something, and make sure that everything's done. So to the extent, the kind of help we get it, for example, in one of our agro products, you will not believe that we get the help from the farmers themselves. कि साहब ये आप कर रहे हो, ऐसा already यहाँ पर ये कर रहा है, please make sure that यहाँ से ना आए, because we believe in you. So therefore, connecting with the farmer, connecting with your customers, connecting with your vendors, connecting with your sales people. So I think as an in-house counsel, when you are handling the IP portfolio, it's very important that you are connected with all your stakeholders to get the intelligence. So we'll discuss later in terms of, action intelligence also. But as a strategy also, one is that in view of, keeping your registration valid, keeping all your track on your registration, etc., future expansion, future diversification. But at the same time, keep an eye as an intelligence on a lot of people. Sometimes we get a good feedback from our salespeople. We get good feedback, like as I told you, farmer. We get good feedback from our vendors also. Okay, sir, we believe in your organization, but this is something is happening in your name, something like that. So we can always strategize. And strategy is also, not every Tom and Nick and Derry is to be raided or to be, enforced. Basically, you have to really make the strategies, which of course we'll discuss in the next question. But I think this is very important that one has to really keep track of all these things.
So that's been said that the takeaway I think from Mr. Gambhir's insight is that having your own IP division inside. So before we approach courts for enforcement of IPD, like before the IPD for protecting brand, you must have your own IPD at your firm, so that at your company, so there are specialized people who are able to monitor the protection of brand effectively. And now I move to Shhaurya for giving insight about, we have discussed about filing of trademarks, then foreseeing different classes of allied and cognate goods, and also having own in-house team, a strong IP team, separate team, which is involved in brand protection. So apart from that, since you bring in the expertise of cross-border protection where the products are imported, so if you would like to throw some light on custom recordals as a mechanism to make your house strong, because if the goods are imported, and how at the shores itself these steps can be taken to protect brands, and then we will come on to the challenges also, that what are the challenges attached to those custom recordings. So over to Shhaurya.
Thank you, everyone. Rightly spoken by the previous speakers, like it is very important to have your registration in the allied cognate classes also. Very important thing is, as you mentioned about custom recordals. So my father was actually into agrochemicals company, and he used to say that to have a better yield, it's very important that you have a better pesticides, right? Because eradicating weed from the root is really important. So that is exactly what custom recordals also do. So when so as rightly pointed out with Mr. Gambhir also, you need to know your potential markets. You need to know not only where you are present. So see, we are Indians, we are present everywhere, right? So wherever our population is there, wherever Indian diaspora is there, it is very known that that country will have a well-known a trans-border reputation of the brands which are manufactured in India. So needless to say, even if you are not present in that particular country, for example, if minus in some South Asian countries where Indian diaspora is not too much, but still it is needless to say that there in those countries, your goods or your services would reach, right? If it is not going through your channel, by some import channel, different import channel, it is definitely reaching there. So there are hundreds of videos now available on YouTube where even one purchaser, one like small player can get those goods imported into your country, right? They have made everything so clear that how to install VPN, how to do like different, so that you don't get caught. Even one person with charges of $100 1 cubic meter is there for importing, like that is like what one player has to pay to get the things imported. So it is really important that you identify, if for example like from where the goods are originating, right? This is where identifying the route is important. So, as per the USPTO's data of 2018, uh, just for counterfeit goods and like international sale of counterfeit goods were up to $4.5 trillion, and 80% of which was actually manufactured and sold from China, right? So, if we are talking about counterfeit goods minus China, only 20% is being manufactured in else countries. So it is important to identify if it is being manufactured in China or wherever it is manufacturing. So for example, if your group is based out of India and you think that you are not selling your goods outside India, then think about it twice, because we have got clients where they are actually operating only in India, but their goods are being manufactured in China and straight away going to the ports of US. So it is important that you get a custom record done not just in your country but in China also. For that, it is prerequisite even in China that you need to have registrations and your IP rights done in China. Even if you are not operating just for the sake of protection, you need to, I mean, for enforcing your rights at the ports, it is important that you should have your registrations done in China.
So, yeah. So that's being said, the takeaway I think is that as a brand owner, we should not restrict to our own country for making our house strong, because we those are like the farmhouse of the on the other shores, where the brand is to be protected on the desired market, where the brand is actively trading, and there is a possibility of counterfeit goods being imported from that channel. So that being said, in addition to this, I would also like to add few things which can be used to make your brand protection strategy a bit stronger. Yes, we have filing of trademarks, patents. Making our IP strong is the first step. Then, and also foreseeing that what kind of goods we are getting into. Like, for example, it is now we never thought of infringement on a digital space. So now we file like for the metaverse, we have to file. All brands have picked up and started filing in that particular class. So that is very important. Then second requirement may be use of technology to protect your brand, like having QR codes. Uh, there is a mechanism which most pharma company would have, is having a QR code to scan if the drug is original or not. There is an extra step added because for pharma companies there is added liability if the drugs are spurious in nature under Drugs and Cosmetics Act. So these, because these are not the consumerables, but this can also result in the public health and safety. So each industry specific, like for instance, in fact, I've seen a very common example day to day, even on protein shakes, like whey protein, you have this QR code intact because uh, the infringement was rampant in that particular industry. So these are the certain methods. One another method was that you can verify if the drug is original or not by sending an SMS, and then there would be a reply that yes, you have bought a correct medicine and it's the correct source. So these are the ways, additional ways which can help us to protect a particular brand. Now, the second part of the conversation, we move to this is the preventive steps which we can take. Now we move to diagnosis. Let's say, I think Shhaurya touched a bit on the diagnosis part, that how we are going to identify what are the sources that whether a brand is protected or not. Maybe we think that the house is quite strong, but whether are we able to check those leakages? what are the ways in which we can figure out if there are any parallel imports. We may have custom recordals in place, but if there is a parallel import, or the product is A, but it is shipped as B, then how we are going to, how we are going to identify. Combating would be the third part of the discussion. Now, what are the best practices and challenges? I would like to ask Mr. Aggarwal about what are the best practices in terms of uh, diagnosis and figuring out how that if there is any counterfeit which is happening or not.
So I would just like to add a little bit of, on the custom recordal aspect from my experience. We have our brands, in the African as well as in the Chinese territory. The custom recordals are in place for us for the last almost 10 years. So it's not that, as a remedy, it is toothless or, it is not very effective. It is, in fact, more of a fishing exercise. It's not much you can do. You are always, dependent upon the people who are on ground at the ports who are responsible for checking the shipments and the consignments and the documents. Because the number of shipments which are moving from any port, be it, India or even to the high magnitude of China, where more than lakhs of shipments are moving every day, it is practically and technically not possible for the authorities to physically check or inspect each of the shipments and the documentation that attached to it. So it is some kind of intelligence which you have to generate on your own and to assist the customs authorities so that they can intercept the most suspected or the right kind of shipments which you are looking for at the right moment. So for this you need to have your own intelligence network of people who are on ground in the relevant markets. For example, there are one or two ports which are very prominent for our lighting goods. So we suspect that it is unlikely that a fan or any other kind of electrical good will be exported from one particular port. And even in the lights and products, depending upon the season, depending upon the destination country, there are kinds of ways for you to gather intelligence from the ground. The other difficult thing which we have faced with customs is that you have to regularly engage with the custom authorities. You have to impart them training. You have to make them well acquainted with your brand, your company, your products, the kind of problems which you have, which these kind of training programs are organized by the law firms, the intelligence agencies, and the authorities themselves. So you must ensure that as a brand owner, when you are in such places like difficult ports in China, the brand owners who are responsible for the brand in India, they directly should have a contact and regular meetings with the customs authorities. That is one of the most important things. Once you have your brand has a visibility and a recall to the custom authorities, they are definitely going to find some kind of hanky-panky which is happening, and sooner or later they are able to help. Initially, for the once we had recorded our brand with China authorities, there was hardly any seizures, but we realized that the authorities were not aware of the problem which we actually were facing. So we had to meet them, we had to tell them these are the products, this is how you have to identify. So meeting and having a good relationship with custom authorities is most important. Then the other couple of things which we find are very dissuading as far as customs seizures are concerned is that you have to deposit the bond money. Whenever there is a seizure, you have to pay a certain percentage of the invoiced value with the authorities, and then you have to pay for the warehousing fee. So that is also one of the challenges. And once the adjudication takes place, which takes almost somewhere between 6 months to a year, you have to keep paying for the rent of the seized products. And once the goods are adjudicated to be counterfeit after the entire administrative process, then the goods are destroyed. So even the destruction fee has to be paid by the brand owner. And because of the number of layers in which the actual manufacturer, then the shipper, then the export agent, and the person whose name will be finally appearing on the export documents, there are so many layers that you just can't scan through the number of people involved in the change, and you are never able to find the manufacturer or the ultimate consignee in the African country. So ultimately, you end up spending a lot of money, which you are not able to recover from the actual culprit. So that is a kind of a little bit of a deterrent, but we see it as an investment because whenever there are seizures, there have been instances where we have seized material worth more than 100,000 US dollars twice in a month, and there have been some instances when, because of the substantial seizure, the activities have gone a little underground, or they get a little slowed down, or they shift to other ports. So instead of looking it as a cost, we have to look it as an investment when it comes to spending money in China for the custom practices.
So I think there are a lot of, I was not aware that these are the challenges which are attached to the custom recordals. So that's being said, are there any further challenges when it comes to actually figuring out whether the counterfeit has happened or not? So I would like to ask Mr. Gambhir that in his experience, how he's able to figure out that there is that what are the best practices in terms of identifying counterfeit.
Thanks, Nihit. I think it's very difficult. Basically, depends on the product to product, market to market. I still remember, we were consulting. I was into consulting earlier, and we were doing a very big assignment for a brand production for a company, multinational company. And to our surprise, we did all kind of intel and all, and a lot of intel has gone into a lot of investigation and gone into it. And to our surprise, what we were seeing were that things look absolutely similar. The kind of training our people got from that particular company, they were all trained for that identification of that good, but still they were not able to identify at some goods whether these are counterfeit. And when these reports were sent to the headquarters, we came to know that a couple of these are counterfeited. So thanks to our friend country China, I think these were all importing from China at that point of time. So up to that extent, the technology or the things have been copied, or maybe I would say with that greatness. So ultimately, people from the headquarter came, they gave additional training, and they say, okay, two of us will be there to understand that how do we identify, and they had a different kind of a techniques to identify. And to our surprise, when we sent the decoy customer to find or to buy these products in multi-cities, it was a multi-city enforcement action we were doing in the India. And the moment, for example, you take 10 products, and surprisingly, 5 were counterfeit, 5 were original. And even the shopkeeper or the trader was very, he was actually surprised to know that I'm selling counterfeit, because he was not even aware of that I'm selling the counterfeit. He was getting the supply of original products. And within that original products, there was a mix of counterfeit products. And no one knew it, not even the local people of that company were able to identify unless the experts from that headquarter came. And these were imported, and at one point of place, somewhere at the channel partner level, they were being mixed. So, the enforcement action, the guy was arrested, the shopkeeper, the trader were arrested. So finally we thought he's innocent guy, because he even doesn't know that he's actually selling the counterfeits. It's so difficult at times. And up to some extent, there was very, very difficult. And then finally what we did was, in that case, we went a step further and tried to understand that where actually it is happening. The things were being imported from China perhaps, and at one point of time where at the middle level these were being mixed, and when the original supply was sent to the trader or the shopkeeper, these were being mixed in that upfront time. So then we decided to frame, we did another intel. We try to break the channels in between, instead of giving or arresting the shopkeeper or the trader, try to get the person who is actually doing that. So this was a very unique experience wherein we realized that, even the person who is selling counterfeit was not actually aware of it. And so we tried to break the channels in between, and up to some extent when we did break the channels, we realized that, a lot of things have been cleared actually, and the organization was really happy to that strategy. So point is that it is very difficult at times to understand for you also that it is actually a counterfeit or not, and what kind of a strategy you have to make. For example, I don't know how much actually this is losing my revenue share or market share, whether it is actually a great dent or heavy dent to my product or to my reputation or not. If it is a food product or if it is a medicine, it's actually going to be very, very dangerous, because it's a health issues, safety issues. If it is any other product which is a very big product but a multinational company, there are chances of the funds are being used for terrorism or other things also. So there are other aspects also included in that. But that's where we realize that identification is actually also is a very, very great technique wherein sometimes you need really, really experts. The other thing I really support is that whenever you start your intel or whenever you start your investigation, etc., in the strategies, make sure that the law firm is involved, the IP law firm. Your IP law firm is very important to be involved from the day one, because that's where they will keep you advising that that you're going in a wrong direction or you're not going in a good direction, because you don't know what kind of a impact on the organization can also come. You don't know what kind of a impact you also can face. There are strategies. Sometimes people say that you have to publish in the newspaper that there's a raid. Sometimes people say don't publish it, then there will be brand image to your organization also. There are many strategies you have to see product to product, I think. So I think you have to really see the market wise, product wise, whether it's FMCG product, whether it's a big product, medicines, or in COVID time we have seen a lot of counterfeit, which was actually a health hazard.
So that's brilliant that we know that diagnosis itself is quite difficult. So one of the examples which I recall, that how difficult it is that sometimes the dealers itself are not able to understand that they are selling a counterfeit product. I'll give you a live example of a case which we happened to handle. This was a consumer dispute wherein a tire company was involved, and they had sold certain tires to the consumer, and then there was a major accident which happened because of the faulty tires, and the dealer was sued and the company was sued. This is one of the leading brands, and to our surprise we figured out that the tire itself or the itself was a counterfeit product. So, because there was no ample checks to figure out that how a counterfeit product has sneaked in to our original dealer. It was a proper verified dealer from where the tire was bought, but the tire was duplicate. So that has happened, and that has resulted in another legal action, which is a consumer complaint. Now it was a very difficult proposition for to handle that particular consumer dispute, saying that we do not have any liability because dealer is real, product is false. So these are certain, although the case got settled ultimately, but these are the problems which may arrive when there is a lack or a gap in understanding that how these counterfeit products are circulated in the market. So one of the other example would be parallel imports, where the product is real but the channel is not correct. So over to Shhaurya, if you can highlight about something on parallel imports, that how it impacts the brand owners, where let's say there are certain guidelines in terms of MRP, or for example, for the vegetarian food products, for India you have to have a green dot, which you might not need in Dubai, for instance. And if you are importing those products parallelly, those are real products, but then ultimately the liability is going to come on the brand owner. So are how parallel imports per se, is there any fixed mechanism where we can check that how the parallel imports uh, is taken care of, and we can identify that certain or whether it would be counted as a counterfeit at all when we say that the products are original but they are not legally imported in India, let's say.
So basically, as we all know, like parallel imported goods are actually original goods only. So another word which is used for parallel imported goods is grey goods, right? So it is still, for us, definitely in India, it is still considered as not an original goods, right? So we know, like in Gurgaon, there were lots of factory outlets which just got stopped, like their outlets are still there. But considering that it was not an authorized channel of sale, definitely that would come under infringement, right? So anything so whenever you are having a brand, it is very important that from top to bottom, you need to have a robust strategy done, where not only registering your rights is one particular thing, but also with respect to how your agreements are in place with respect to your maybe manufacturer, maybe your packager, what exactly is your agreements with them, that needs to be robust. So in order to curb that, like generally what challenges that we are facing is that our client, basically they do not have certain agreements in place. For example, they are having they do have a contract with the packagers, that we will be taking these many packets with you from you, we will be taking these many packages from you, but it is, there is no contract that whether after, for example, 1,000 consignments are done, you cannot print 1,001 consignment. So in recent case that we found that very leading like rice manufacturer, one of the company, they did not have that agreement in place. And the counterfeit that was happening, I mean, we all were spellbound. We were astonished to see that the similarities that were there between the packaging, the goods inside were not the same, but the packaging was the same, right? Obviously, QR code was in place. We scanned it. We saw that, yes, it is coming from the right channel. But again, the goods which are inside that is not is fake. So at that point of time also, you need to understand that you need to restrict each and everyone from top to bottom with respect of your goods, with respect to your, like NDAs should also be there in place, that once you have like given us the consignment, next consignment should not be there with respect to that particular printing. Then again, there are lots of packaging companies which are there in market, who some of our beverages company, they are actually taking help of them, where printings are done in a very advanced manner, where after certain printing is over, you cannot start next printing will be automatically stopped from the system itself. So that needs to be checked. And yeah, basically, in short, parallel importation can, I mean, definitely see it, infringement will happen, right? It will not stop. Once you take an action against one wrongdoer and you will think that another person is not going to do that, that is not the case. Yes, you can take a precedent from one particular action that you have taken in past, and you can stop the next. Now, coming to again like challenges, some of the challenges which I would add up to the previous speakers is that definitely when we are fighting the counterfeit, we do custom recordals again, but in practicality, it's only 5% of the containers which go under scanner, right? So 95% are still open, cannot be opened. Whatever is going through that, you don't know what exactly it is going through. So that is one drawback, again, I would say, with respect to that. Now, again, coming back to parallel importation, I mean, you definitely need to have a good intelligence in place in order to fight parallel importation also. Because as I said, even parallel imported goods are actually your good only. So, yeah, I'll pass it.
So that being said, that imitation is best form of flattery, but now if but not in the legal sense. If the imitation has happened, then it demands a prevention, a cure, where you want to take certain actions when it comes to counterfeiting. So I would like to ask, what are the best actions? We all know what are the actions against the counterfeit goods. We can take civil actions, we can take criminal actions, we can send cease and desist, we can do pre-litigation mediation. So from the industry experts, I would like to ask, what is the best cure to counterfeit? And also, later on, we want to summarize it a bit with the way forward when it comes to protecting brand as a whole, and what are the anti-counterfeiting steps which can be taken by various brand owners. So, if Mr.
So, as far as taking steps, what I would like to add is, in our Indian context and the legal framework which we have, it is, in addition to the civil actions, the local commissioner raids, the police raids, these are the, basic things which have been, which brand owners have been doing from times immemorial. So I would like to share a little bit of my experience regarding the remedies which we have taken in the African and the Chinese territories. In China, litigation is very costly. We, in fact, did sue one of the biggest B2B platforms. They were selling our counterfeit goods, which were originating from China and going to Africa. So, in fact, the packaging which was seized by the custom had made in India branding on the packaging, which was seized at the Chinese port. So the seller, and somehow we could manage to gather intelligence that the seller was having substantial presence on Alibaba. So we had sued Alibaba in China, and we were able to secure interim injunction and permanent injunction also against them. And then, but finally, for the repeat listings, there was, identifying and suing each of the listings in China was going to be a very costly exercise. So ultimately, we had to take recourse to the Indian courts, and we sued Alibaba in Delhi High Court, and we could finally get a favorable order now, wherein we have interim orders that whenever we come across any listings, the same are pointed out, and within 48 hours they have to be removed by Alibaba. So suing a giant like Alibaba, and overall during the pendency of the proceedings with them, we have reached a certain stage of discussions with them where they are willing to collaborate and modify their algorithms to suit the typical kind of a problem which we are facing. Unlike any other brand, maybe if we take the example of a Louis Vuitton or a Nike, where the products are not only manufactured in China but also sold in China. Ours is a very typical case where some of our product range is manufactured in China, but it is not sold in China. So we had a discussion with Alibaba that it is a very simple kind of a algorithm which you need to prepare, that if someone is selling Havells branded products who is having his place of origin in China, that is the simple thing which you need to identify. So they have been in discussion with us, and they are willing to bring in and tweak in their algorithms. So it is that kind of a repo which you have to build with these kind of platforms, because other than the basic intelligence which you need to do in market, you need to have a very deep or a specific eye on the e-commerce platforms. So keeping an eye on e-commerce platforms is very necessary when it comes to the Chinese context for the sourcing purpose. And similarly, there are the counterparts for the selling or the B2C kind of websites which are there in the African market. So now we have started taking action in African markets also, where the courts have granted us injunction and given us the liberty to approach the platform to write to them to take down the listings. And in our experience, we have always found that taking the court route for direction to the portal is always better than directly writing to the e-commerce platform by taking recourse to their takedown mechanism, which we find is always very subjective and open to interpretations, and it's not very effective. So that kind of a strategy has worked for us very well, wherein the sourcing for B2B platforms like Alibaba made in China, and then the B2C kind of platforms which are country specific, to take recourse to them by suing them and taking injunctions against them for taking down the listings. And in my experience, some of the jurisdictions in Africa like Ghana and Kenya, where we have found that the civil route, although there is a negligible chance that you are going to get anti-penal orders, but because even if you are able to secure such orders, the execution of the bailiff, or what we call as the local commissioner, is very difficult, because there have been 2 or 3 instances where the team of as many as 10 police authorities, court staff, they were attacked by the rioters. There was riots, petrol bombs being thrown. Some people of the raiding team got injured. So in my experience, it has, although the courts have on 1 or 2 occasions granted orders for Anton Pillar, but the execution is very difficult. So the remedy which we find better and good is, although it does not give you immediate result, is to file civil actions as far as the Western Africa is concerned. And in Eastern Africa, in my experience, the raids with taking into confidence the local authorities like police, and some of the countries have special authorities and special legislations for tackling anti-counterfeit products. So taking recourse to those kinds of authorities has proven to be more effective than the civil remedy.
Yeah, thanks, Harsh. I think this was really wonderful. In fact, as you said, that all these practices are available, all these remedies are available, and depending upon the area, depending upon the market, we really have to strategize the things. In India, we have a special task force now, special cells now, they are really helping. So I think in some cases, we have found that the criminal action is actually very useful in India, but the civil action is also very effective. We have seen custom is also. So in one of the example I'll give you, we were helping one person to kind of a raid or enforcement action. So I was just talking to him, and casually I said, "Yeah, why are you going for action, intel and all? While a lot of product of you, I can tell you that selling in Gafar market were $100 rupees, Okay, so we have. Sure. So I was just talking to him casually that all your products are selling in Gafar market here, you can go and buy it. He says, Sameet, my problem is not that, I don't want to waste time and money on selling, doing enforcement in Gafar market and all. I know that. Once in a while I can do that, all these will be clear, then they'll be somewhere else I do. The point here is that who is actually making dent on my revenue and my market share and my importance and my reputation. So point is, someone who is actually buying from Gafar market or from the gay market knows that I am buying a counterfeit product. So that's not my problem. The problem is someone who is actually buying it, understanding it that I am buying original on a 20%, 30% discount, while he is actually being sold the counterfeit product. That's where my problem is, because my reputation is at dent, my revenue, my market share, everything is there. So, it depends whether you have to take a criminal action. You really have to give them a clear lesson that this is what we can do. It depends, at places where you have to go for a civil or court commissioner order. So actually it's a strategy. One has to really see that, depending upon your market share, depending upon your area, depending upon the kind of product, the value of the product, everything makes a lot of difference when you make your strategy. So he says, even if someone who is trying to, because buying counterfeit is it's not illegal in India, I think in anywhere. So he says, if someone wants to wear a brand, it's okay. He's buying it from a place where everyone knows that a counterfeit brand is available at a cheap rate or something. It's okay for me. Once in a while, agar kabhi kuch dikhana ho market mein, we have to create a fair. We can do once in a 2 years or 3 years. We can do a massive action there. But problem lies where my actual consumer is being targeted. So I don't want my actual consumer, who is actually consumer of my product, to be sold counterfeit and all. So I think, and then similarly in the civil actions also, it depends, how much the material is there. Sometime, someone is actually producing a lot of material, then you have to go and get the order to, stop production kind of a thing. So it depends your product, your market, value of your product, effect of your product, impact on your organization, impact on your reputation, everything works together, and then you have to find out a clear strategy. I think it's very, very important.
Correct. So that's being summarized pretty well. Now we can take up, Shhaurya can take up two questions from the audience, which is in continuation of the prevention itself. Those are India specific, and I think Shhaurya would be the best person to answer these. What are the mechanisms of fixing brand violations in India? Are these proofs of violations accepted by the courts? So primarily the question is India specific, that what is the mechanism in place today to protect a brand, A, and B, the proofs of violation accepted by the court. So
So, so the key to like good brand strategy or the best practices of brand strategy is to have a robust prosecution of your mark, right? So if you are having a good registration strategy, definitely it is going to be the first step towards like having a brand like mechanism for fixing the brand violations. So it is not necessary that if you are a cosmetic company, you are only getting the registrations done in class 3. So as we see, there are so many allied and cognate classes where your marks fall. So when, for example, you are doing recordals and customs or raid for that matter, it is not necessary that you are only focusing on cosmetic products only. So the way the things are coming inside the port is like we have found that for cosmetic companies, we are also focusing on the packagers. So the people who are actually making, also people who are making brushes, people who are making leather pouches. So like all these, like so basically, for example, cosmetic fall under class 3, but we are also taking action against people who are getting registrations done in class 21 for that matter, class 16 for that matter, and then class 18 also, class 25 also. So these are all the allied and cognate goods in which, or the classes in which you need to get your registrations done. So you need to have a foresightedness with respect to that. That is first. Second would be take an opposition action, take like, go through, get in touch with a law firm who can do a robust, a strategy for you, who can guide you further with respect to enforcement of your marks. So we will just scan through all the classes of goods where bad faith registrations are there. If opposition period is still there, just file an opposition. If not, file bad faith cancellation and rectification against them. If you see if you see them in market, just go against them. Also, as it was previously mentioned by Mr. Gambhir also, that there and you also, that in pharma industry, QR code is already in place. As I said, there are packagers also who do make smart packaging where you can understand just by the product, scanning the product, the origin of that product, right? So that needs to be there in place. Then again, take the help of the well-known nature of your mark, right? It is very important. If NR Dongre's case is anyways a landmark which is there, which would give right to rightful owner, even though that owner is not present in India. Very fortunately, we are present in a country where we give weightage to rightful owner with respect to a first file country. So most of the notorious markets that we know is actually playing on first to file principle, right? India fortunately does not focuses on first to file principle. So if you have that registrations done, then definitely your mark would get protection. Second question, I would say, I mean, this statement would also answer the second question, where are these proof of violation accepted by courts? Yes, so bad faith registrations, bad faith, they do, I mean, they play a vital role if you can prove a well-known nature of your mark.
So I think in the interest of time, I'll just like to summarize the way forward. I'll just take 2 minutes. From the session, we could figure out that the way forward. What is the way forward? Way forward is to protect counterfeiting. The laws, the mechanism for fixing the counterfeit is to be industry specific. Especially like pharma, we have Drugs and Cosmetics Act, where a separate action can be taken under with the food inspector itself, because public safety is at the risk. Then we come on to online counterfeiting, where there are separate rules. For intermediary liability also there are certain rules where the intermediary is held to be responsible for certain counterfeit acts under certain circumstances. They cannot claim that immunity. So the way forward to protect a brand is of course the technology catering to various checks and balances where we are able to protect the brand, plus having laws, guidelines. For example, we still have for influencer media, we still have just the guidelines. For ASCII, this advertising, we just have those guidelines. But are these guidelines enforceable by court of law? So these are the things which we need to work upon, to tailor-made and customize, and also when we speak about parallel imports. So for instance, parallel import has happened, but then the landmark Samsung judgment, there is a principle of exhaustion, that if I have imported the goods from the right source, then I have right to exhaust those goods also. So there are certain challenges which are industry specific. Hence, there is a need to make laws which are also industry specific. Although it is impossible to make a law for each and every industry, but a wide consideration can be given. For metaverse, for AI, we must have those rules in place. So I think the way forward to combat counterfeit is to identifying various gaps in the legislation, where we can fill in those gaps and have and equip the brand owners with a better mechanism for brand protection. Anything if the panel would want to add?
Very well summarized.
Thank you. Wonderful session. Wonderful. I mean, I like the example of Alibaba. Now we are so confident that if that can be done, an online counterfeit can be stopped. Amazing. So in wrapping up, may the echoes of this session resonate in your pursuits for greatness. A huge thank you for an outstanding panelist for this profound impact on today's discussion. Special thanks to the skilled moderator for a very seamless and informative session.